If you have a felony, it could feel like certain careers are permanently closed. Lawyer might be one of them. So let's answer directly. Yes, a person with a felony can become a lawyer in some states, but it is not automatic and it is not guaranteed. The biggest barrier is usually not getting into law school. The biggest barrier is the state bar's character and fitness review. That review is where the state decides whether you should be trusted with clients, legal cases, money, court duties, and professional responsibility. This is not meant to discourage you. It is meant to protect you because law school can cost a lot of time and money. Becoming a lawyer usually involves three separate gates. Gate 1 is getting accepted into law school. Gate 2 is graduating, then passing the bar exam. Gate 3 is passing character and fitness. The last gate matters a lot. A law school may accept you with a felony. You may work hard for 3 years. You may even pass the bar exam. But passing the law school and the bar exam does not automatically give you a law license, because character and fitness is also part of bar admission. That means the state bar can still delay you, question you, or deny admission. The NCBE may help with character and fitness investigations, but each state decides who can practice law there. So before you choose a law school, do not only ask, will this school accept me? Ask, can I realistically get licensed in the state where I want to practice? The question can save you years of stress. Character and fitness sounds vague, so let's put it in plain English. The state is asking, can this person be trusted as a lawyer? Lawyers handle other people's money. They give legal advice, they deal with courts, they may work with vulnerable clients. They have duties that require honesty and judgment. So the review looks at more than test scores. Character and fitness applications commonly ask about criminal history, employment, addresses, school discipline, financial history, and references. Your felony matters, but it is usually one part of a bigger picture. The bar may look at what happened, how long ago it happened, whether you have stayed out of trouble, whether you accepted responsibility, and whether you can show real rehabilitation. That does not mean every case gets approved. It means the question is usually not just, do you have a felony? The question is, what does your full record say about who you are now? Rehabilitation is not just saying, I changed. It is showing a pattern over time. That may include years without new criminal trouble, steady work, finishing school, completing treatment or counseling, doing community service, paying debts, building strong references, and taking responsibility for the original offense. No single item guarantees approval. But a strong case can usually show consistency, honesty, responsibility, and evidence that the person applying today is not the same person who made the mistake years ago. Timing also matters. If the conviction was recent, the state may want more time and more proof. If the conviction involved dishonesty, fraud, theft, violence, or abuse of trust, the review may be harder. That does not always mean impossible, but it does mean you need a serious plan. This is the first mistake you need to avoid. Do not hide, minimize, or guess your record. Incomplete disclosure can become its own character problem. For example, if your law school application says one thing and your bar application says something different, the bar may treat that as an honesty issue. And yes, that can be worse than the old case itself. Bar Admissions Authority may compare your character and fitness application with what you disclosed on your law school's application. So be careful from day one. Do not assume an expunged case never needs to be disclosed. Do not assume a dismissed case never needs to be disclosed. Do not assume diversion, probation, or an old plea is automatically off limits. The rule depends on the state and the exact wording of the question. California says no single act of misconduct automatically disqualifies an applicant. and that a misdemeanor or felony conviction alone does not automatically prevent a positive moral character determination. That sounds encouraging, but it does not mean California ignores the conviction. Texas is different. Texas treats felony convictions and felony probation as serious bar admission issues, and its rules include a 5-year period after completion of sentence or probation before certain applications can be filed. Virginia requires applicants to prove honest demeanor, good moral character, and fitness to practice, and it lists commission or conviction of a crime as relevant conduct. So do not build your plan around something you heard online. Check the state where you actually want to practice. Read every question carefully. Answer exactly what it asks. Keep copies of every application you submit. Get your court records early. Do not rely on memory from 10 or 15 years ago. And if you are unsure, talk to a character and fitness attorney before you apply. If you are seriously thinking about law school, start here. Choose the state where you want to practice. Read that state's bar character and fitness rules before Read that state's bar character and fitness rules before applying to law school. Get your court records and know exactly what is on your record. Compare what law schools ask with what the bar will ask later. Be honest and consistent on every application. Talk to a character and fitness attorney before spending serious money. And start building proof of rehabilitation now. A felony does not automatically end the possibility of becoming a lawyer everywhere. But the path is serious, state-specific, and honesty matters from day one. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsocietyhq.com for more information.